To start with, business and immigration law updates. This is a proud presentation of the Khurana Law Firm, where the chief residing attorney and counselor at immigration law is Mr. Ramesh Khurana. The law firm is located in Gaithersburg, Maryland. The moderator on this segment is attorney Kenneth Haber from Boyd's, Maryland. On this set, these two attorneys' discussion will reveal the last action rule of the USCIS. Let's see.
Welcome. I'm Ken Haber. I'm a former Assistant United States Attorney and a former Senior Attorney in the Office of Inspector General of United States Department of Health and Human Services. That's the Medicare cops. As an Assistant U.S. Attorney, I used to prosecute them. As a Senior Attorney in the Inspector General's office, I used to bag them up and send them over to the U.S. Attorney. This time, what we have is immigration presentation by one of the best immigration attorneys that I know, Ramesh Khurana.
Thank you very much, Ken.
And this is the Capitol Forum. Welcome. Ramesh, can you elucidate a bit concerning the last action rule of the USCIS?
Sure. Ken, the last action rule, which basically is prescribed or formulated by USCIS, is a very critical rule to know. That means what is the last action which is taken by USCIS in regard to a particular beneficiary. To give you an example, you apply for H-1B today, and H-1B is approved in about 4 weeks. And while this petition is pending and you have been working on L1 visa, your L1 visa employer also files for extension of L1. So your H-1B is approved in 4 weeks and your L1B is approved in 6 weeks. So that means last action taken by USCIS is in regard to your approval of L1 visa. So which will basically eclipse or overshadow the previous action taken by the USCIS, especially when you don't go out of the country and you continue to stay here in the United States. Please watch out that kind of situation. You may be in trouble.
Are there some conflicts at times? You're saying people could be in trouble. What sort of conflicts would arise?
No, main thing is which is the last action chronologically taken by USCIS. In this scenario which I have explained, the last action taken by USCIS was the approval of L1. Now, if that person, let us say, tries to move to his H-1B employer after the L1B has been approved, and then you wait for 2 more weeks, and then you come to the H-1B employer and say that my H-1B was already approved. No, I think probably it has already been overshadowed by the last action taken, which was the approval of the L1 visa.
So that could, in effect, adversely affect your H-1B employment.
Yes, because you are not in H-1B status at that point of time.
What would a person want to do to avoid that type of situation?
You know, there are 2 ways. One thing is you go out of the United States and present yourself before the US Embassy or Consulate, apply for H-1B visa, and if they approve your H-1B visa and issue a stamp, then you can enter on H-1B visa. Otherwise, you have to file your H-1B status again, H-1B application again. You cannot start working on H-1B once the L1 status is approved and you have been continuously working on L1 after that. So you are not in H-1B status, so don't start working with a new employer on H-1B without filing an amended petition.
So basically, you're just going to have to amend the petition to go back to where you were.
Yes, you got it.
Let's say you go back to where you were, so you had your H-1B, that then eclipses the L1.
Yes, because then the last action taken is the approval of amended H-1B petition. So it is in tune with the last section rule.
So let's say you go through your H-1B employment Now you want your L1 employment. Is there a easier way, is there a quicker way now that you had it once to get it back?
You know, there is no easier way because every time you file any petition for any immigration benefit, so it is going to be adjudicated based on the strength of the petition. But once you are on L1 status and you want to come back because you qualify all the factors required for the L1 petition, so that will be approved based on the merit.
So you just have to go back to the merits again.
Yes, yes.
How does this work between the H4 and what is the H4 and what's the H1B we're talking about, and how does this work in connection with these two?
Yeah, this is very important, Ken, and this is a very good question. And many H1B employees and their spouses who are on H4, they get affected in the process. The way it works is, probably I will give you one hypothetical example. Let us say that a person is on H4 visa, being the spouse of an H1B holder. You apply for, you get a job, and when you get a job and you apply for H1B status, and your H1B status is approved. But in the meantime, let us say that you lose your job, and if you lose your job, so you are not in status, you lose your H1B status and you apply for H4. So whatever is the last action taken, that will continue to prevail. It happens in a kind of situation, let us say that H1B is approved as from October 1 of the year and H4 expired in June, and your last action taken was basically H1B. If it is October 1 and your H4 is valid up to September 30th, you are good. Otherwise, if H4 has expired and you apply for H4 again, and if it gets approved on October 15, so your H1B was approved as from October 1, your H4 gets approved as from October 15, so last action will be H4. So in that kind of situation, better you withdraw your H4 application right away so that it doesn't become the last action.
So you can withdraw them then?
Yes. But one thing we have to remember, that last action rule is the rule which is basically made and followed by USCIS. I do not think that this is a statutory rule. It's not a statutory rule, but USCIS would like to enforce it.
Well,
Yeah.
in as much as that they're enforcing against people who are not citizens yet, they have a lot of clout in doing that.
Right. You know, I have seen many H1B people getting into trouble, especially when they are switching from L1 to H1 and from H1 to H4, and they have to make sure what was the last action taken by USCIS.
And I bet to complicate things is when their spouses are working,
Right.
based upon the fact that the husband has a visa,
Right.
and they're obtaining a work visa based upon the husband's visa, and the husband's visa changes, then they could be out of status themselves.
Yes, yes. One more thing I would like to explain to the audience here. Let us say that your H1B is approved and you continue to basically be on H4 visa status. So make sure that you start working on H1B visa only from the date of approval and not before that. And other thing is, let us say your H1B is approved from October 1 and you want to go overseas. You go on a cruise vacation and you go to Bahamas outside the United States. You spend your vacation time for 7 days. After that, you return before the date of approval. If you are returning to the US before the date of approval, so international travel is not treated as the last action taken by USCIS, because the last action taken by USCIS was the approval of H1B petition as from October 1.
Is there any way of slowing down the process so you don't have to withdraw your application, but you can ask them to slow it down so that it will coincide with your employment opportunities that you have available?
Once you have made your application or filed your petition, H4 petition is filed as a regular petition. There is no premium processing. For H1B, there can be a premium processing, but there is no way that you can slow it down. For H4 petition, you cannot even say that I should be given H4 from a future date, let us say after 6 months or 8 months. H4 petition becomes operative from the date of approval. Sometimes H4 petition gets approved in 2 months and sometimes even 1 month, and sometimes it doesn't get approved for 6 months. So it depends how many people are ahead of you in the queue. So only thing you can do is, once your petition is approved and you can foresee that now you don't want to be in other status for which application is already pending, withdraw that application.
Would they use the paperwork that's already been processed if you want to renew it again so that your application moves quicker? Or do they start all the way at the very beginning and just throw away the file that they've already accumulated?
In fact, whenever you file a petition, now they start adjudicating that petition based on the self-contained documentation. They will not refer to any other petition which was filed last year or last month. They have to make the decision based on what is before the adjudicating officer.
So the best you can do is, if you have to withdraw it, is make sure you accumulate a good, clean copy. Do these have to be original documents or?
In order to withdraw the petition, basically you need to have a copy of the receipt notice, and based on the receipt notice you just write to the USCIS that my situation has changed and I want to withdraw my application. But again, H4 application is of the applicant or the beneficiary, but H1B petition belongs to the employer. In that kind of situation, you need to request the petitioner, who is the employer, I am no longer interested to take up this job because of change of my situation. Please withdraw my petition for H1B. And then employer will be writing to USCIS for withdrawal of the petition.
Let's assume that this employer is vindictive and doesn't want to withdraw it, and basically just wants to mess around with you. Is there any way to tell immigration that you're not interested in that job anymore and that this person's continuation is just harassment and that you want to maintain your hold?
In that kind of situation, I would say yes. The applicant of H1B petition can write to USCIS explaining the situation and giving a copy of the communication which he already exchanged with the employer, that this is just a kind of harassment and I am the victim. But let us say despite that fact, H1B petition is approved later, so I would suggest go out of the country and come back on H4.
Well, we can see that the cameraman is wrapping us up.
Yes, yes.
So I'd like to thank you again for appearing and explaining this area of the law, because I'm sure it's not uncommon for people to run into situations where they have, different decisions, and knowing that the last one is the one that applies.
I agree with you. They are complex set of rules, and always talk to your immigration lawyer so that you are guided properly. And last but not the least, I would like to thank you very much for inviting me to the studio, for giving a generous introduction, and I enjoyed every question coming from you.
Thank you
so much.
Thank you.